So agenda item 1 is PE1458, a register of interest for members of Scotland's Judiciary. And the first item of business is consideration of petition PE1458 by Peter Chirby on a register of interest for members of Scotland's Judiciary. As previously agreed, the committee will take evidence from Moi Ali, who is the Judicial Complaints Reviewer, and members have a note by the clerk. It's paper 1 in submissions. And could you please all note that there's been a late submission from the petitioner, Peter Chirby, which was circulated on Friday, and hard copies have been placed on members' desks. And could I welcome Moi Ali to our meeting today? Thanks very much for coming along. The committee is very grateful for the opportunity to put questions and points to you. We won't ask for an opening statement, so I'll put a few questions to you, and my colleagues will then also do that, and then we'll decide what the next step should be on our petition. So the first one, just really to set the scene, a very straightforward question. Perhaps could you describe what the role of the Judicial Complaints Reviewer is?
It's a new role. I've just finished my second year in office. I'm the first JCR. I suppose I'm a bit like an ombudsman, but without the teeth, in that I can review the Judicial Office for Scotland's handling of complaints. So I don't have ombudsman's powers to actually make any determination other than that they were handled in accordance with the rules or not. So it's quite a limited role. It's a part-time role, 3 days a month on average, in fact 3 days a month maximum. I operate on a shoestring budget of £2,000 a year. Yes, you look impressed by that. What else can I say? I've handled I think I'm coming up to about complaint number 54 at the moment. It was a slow sort of start-up, but obviously that's built up really during the second year.
Thanks very much for that. It's useful, I think, to explain to the committee what your role is. Clearly, there's been some coverage of this particular issue in this petition. I mean, one of the arguments from the Judiciary is, well, we don't need a register because there's strong constraints already in the system, such as the judicial oath. How strong do you think that argument is? Is the judicial oath, among the other devices that are there to protect the public, strong enough?
From the people who've written to me, I think it clearly isn't. I haven't had a large number of complaints, so I have to stress that we're not talking large numbers here. But issues have been raised with me about undeclared family relationships, for example. Concerns have been raised with me about memberships of a variety of organisations. So I think it's important to separate really judicial independence, which obviously I think we all treasure, and it's a cornerstone of democracy, and the separate issue of accountability. And I think the two go hand in hand, and I think really having a clear and published register of interests actually sort of sits above that. So where am I leading with this? I think that the more open you can be, the better. And obviously, this is another strand that I think sits above the judicial oath that really lists things that might not be covered by that. I mean, things like, as I say, family relationships, memberships of particular organisations that might be seen as incompatible, friendships. I mean, there's a whole sort of wide range of issues, really. It's difficult to itemise them all, but they're issues that have been raised with me through complaints, where members of the public feel that actually there are a host of things that are undeclared. Unless you go out and look for them, you're not necessarily going to know about them, and that if there were a register of interest and it was published, you could obviously just refer to one point and assure yourself that, that if a recusal is necessary, then you would have the information to ask for that if it didn't happen automatically. And obviously, members of the judiciary do recuse themselves as appropriate. But I think the issue here is that sometimes members of the public perceive there to be a conflict of interest, but without that register of interests, it's really difficult to say, well, actually, you know, here it is on the register, and this is what we think may be an issue.
I think one of the points the petitioner is making, if I paraphrase him, is there's a register of interest for ministers, for MSPs, for MPs. If it's good enough for the politicians, why is it not good enough for the judiciary? How would you respond to that?
I think I would agree with that. I mean, I think in the 21st century, pretty much everyone, I'd be hard-pressed to think of people who are not expected to register their interests in some form or other. And I think, if anything, the move is towards even more transparency. So in the past, a register of interests would be something locked away in a cabinet, whereas today, virtually all organisations publish it on the internet, and it's easily and widely available. So I think that the public trend is towards more and more openness and more accessibility. And I think, as I say, hand in hand with judicial independence has to go accountability. And accountability, I think, really says, you know, these are what our interests are. Everybody else declares them. It's difficult to argue as to why that should not happen for one sector of society, I think.
Thank you very much for that, and I'll throw them to my colleagues to ask questions. Can I start with Chick Brodie?
Thank you. Good morning. I wonder, before I get to the main meat of the questions I have, you say your budget is £2,000 and you've had 54 complaints?
Over a 2-year period.
Right. Is there a problem in, I mean, clearly £2,000 is a problem, but have you any feel for the number of complaints you might get if there was more substance behind? I'm not saying there's not any substance behind your job, but in terms of raising the profile and making people aware much more widely of what the role is?
I think probably not, and the reason for that is that the way the complaint system is structured, you have to make a complaint through the judicial office, and when you get the final letter from the judicial office, it makes reference to me as the reviewer. So I think people are aware, if they've gone through the complaint system, that I exist. So I think having a larger budget would make my life easier, but I don't think it would actually make any impact on the number of complaints that I receive. I think that is what it is.
Okay. Right, I wonder if I may, understanding that you can't discuss specific complaints, you have, however, referred to various cases where complaints have been raised suggesting bias in the judiciary. In order that we can get a feel for the extent of any problem, it might be useful, you know, if we can understand the general nature of complaints that have been made to you suggesting bias. Can you do that?
I can. I mean, what I've done in an anonymous form is I have approached 3 people who've made complaints of that nature and asked them to supply me with a paragraph summarising the complaint and then a paragraph on their views on whether a register of interests would have helped. And I've put X and Y in, so I don't know if you want me quickly to run through those for you. I mean, the first case is, I'll call him Mr. A, who says, and these are his words, not mine, basically, in a nutshell, I'm saying judges in Scotland are routinely sitting on cases when they ought not to. Regarding my own case, had the 2 judges, Lord X and Y, declared their interest in my case, I would have definitely asked them to recuse themselves. By not doing so, they have brought the judiciary into disrepute. A register of interest would have thrown up in my own case that the judges are sitting in judgment of their father's case and that prosecutors, now judges, are routinely sitting in judgment on their own cases at appeal level when, according to the Dean of Faculty, natural justice demands a judge cannot judge his own cause. And it goes on to talk about a classic example is the name changes they make to hide their links to other judges. Lord X was the father of Lord Y, for example, Lord A and Lord B are brothers. And then he goes on to talk about somebody who contacted him, who I'll call Joe Bloggs, who tells me that he took a judicial review against X organisation for refusing to refer his case back to the appeal court. His judicial review was presided over by the brother of the judge that originally rejected the appeal. Had Mr. Bloggs been aware of this at the time of his judicial review, he assures me that he would have asked Lord X to recuse himself from his judicial review. And it goes on to say that he never thought of looking for any kind of relationship between judges, and in any event, they had different names, so how is he expected to relate to them? So that's one example of family relationships. A second example is the case of Mr. C, who has concerns about social relationships between members of the judiciary. In my opinion, there is no transparency within the judiciary, making a register of interests essential to enable public confidence to be improved. This would give anyone appearing in a court case the necessary information, if necessary, to request a judge recuse himself from a case where there can be demonstrated a conflict of interest, if the judge has not already taken that action himself. The register of interests could also cover, number 1, attendance at social activities by a judge, which are organised and also attended by a party in a court case over which he, the judge, is presiding. Impartiality is essential to the proper discharge of the judicial office and to improve public confidence. And then he goes on to talk about special or personal friendships between judicial members and how that can have an impact. And then finally, the third example that I've brought is an organisation, not an individual, who wrote to me seeking a review. And this is about a member of the judiciary who is a member of an organisation that organisation feels is incompatible with their judicial role. And they say, a register of interests in small part addresses this matter. We are of the opinion that any register of interests, if it is to serve the public interest, must incorporate legislation / provisions which allow declared interests of the judiciary to be challenged and remedied where appropriate. It is crucial that this be independent of the judicial office. By this means, our 2-year experience of questioning the personal judgment of one member of the judiciary, resulting in the conclusion that the judicial office was possibly protecting its own, need never be repeated. So those are 3 real-life cases that I have been involved in reviewing.
Okay, thank you. It's fair to say that, based on one of the examples that you've given, that most judges move in the same circle. Do you believe that they might discuss individual cases, or?
I honestly, I couldn't comment on that. I don't know.
I wonder, in terms of what we're trying to do is seek some transparency and try and understand why some judges or those that manage, in inverted commas, the judiciary, believe that they're above the law in terms of bias. I wonder if you can perhaps give your views on having more transparency in depth and confirm whether you think that that is a goal in itself or is relevant to whatever decisions that are made by the judiciary.
I think really having more transparency in any area of life can only be a good thing. I know that it brings a downside, and obviously I've read the response to the petition, which is that it's intrusive and could attract negative media reaction. And I think in a way that goes hand in hand with accountability, that you have to have an awareness of the impact that your actions might have if you have a high role in public life. But I think that greater transparency enhances the credibility of any group of people, whether it's members of boards, whether it's politicians, whether it's the judiciary. And I think what came through very strongly to me in the examples that I've read out to you, and they're these people's words, not my words, is that they all felt that having more openness, more transparency, would actually enhance the judiciary. And I think that's very true. I genuinely don't think that there's widespread bad practice among judicial office holders. I genuinely don't believe that. But I think public perception is really important. And I think that sometimes things happen that shouldn't happen. And without openness, it's very difficult to identify that. And I think when identified, the feeling that I get from the people who write to me is that there's cover-up. I think it's very easy to believe that there's cover-up if there isn't transparency. So I think that actually by having more transparency, the judiciary would be doing themselves a favour by saying, look, there isn't anything to hide, and if we make mistakes, we'll admit to that.
I just wonder one last question, if I may, Convener. Why would you think that the protection of the judiciary in terms of not having to subscribe to a register of interests was written into the Constitution?
Ask the people who drafted the legislation. I don't know. I mean, this is speculation. It's long been the case in this country that there are particular groups who are harder to challenge. I think in the past, one such group was the medical profession. And I think it's very interesting to see now how, I mean, I had a look, for example, at the GMC website, the regulator of doctors, and they now, and I think they'd have resisted this strongly in the past, publish registers of interest and record family relationships of their council members and so on. But that at one time, I think it was very difficult for politicians to take on that particular group. I think perhaps it's very difficult to take on the judiciary, and I think the reason for that is that judicial independence is always mentioned, and as I said, it's a cornerstone of democracy. But I think because there's been no separation between accountability and independence, it's very easy for the judiciary to say, well, we're independent, so, you know, don't interfere in that. And I think unless you separate independence and accountability, you will continue to see legislation in which there is no requirement for more openness and transparency.
Thank you.
Yeah, Angus MacDonald.
Thank you. Good morning. In the spirit of the petition, I suppose I should refer members to my register of interest. Ms Ali, you've indicated to the committee that you've had to complete registers of interest for roles in public bodies such as the Scottish Ambulance Service and the Scottish Police Authority. And you've also stated that you believe this isn't an onerous task or an onerous process. Can you give the committee a bit more detail with regard to your experience of completing these registers, and also expand on your view that such a role is not onerous?
Yes, it's very straightforward. Once a year, you're written to by the Secretariat, probably in a similar way to the way it operates for you, and you're given a pro forma to fill in. They're slightly different for each organisation, but generally ask you about family relationships, possibly the holding of shares or property, relationships with organisations that might have an impact on your decision making, that kind of thing. And it's really just a pro forma that takes no more than 10 minutes to fill in. You fill that in on year one, and on year two it comes back to you and you're asked if anything's changed, and obviously if there have been substantial changes in the interim, you notify the relevant board. And that's it. So 10 minutes in year one and perhaps 5 minutes in subsequent years. It couldn't be an easier thing to do.
David Torrance.
Good morning. The Lord President believes that the existing obligation of judicial independence and impartiality means that there is no need for a register, and that if such register existed, it could impact on the loss of privacy, and it would also be difficult for them to list all their registered interests. Could you comment on that, please?
To a degree, it does involve loss of privacy. I agree. I think that if you have a position in public life, as I do, I think the public have a right to know what gifts and hospitality I've accepted, or what companies I have an interest in. I think that's right. I think that goes with the terrain, and I think people who sit on boards for many years have accepted that the public have a right to that information. So I agree with the Lord President. I think it is intrusive, but I think that's the price that you pay in an open and accountable society.
Thank you.
John Wilson.
Thank you, Convener. Good morning, Ms Ali. Ms Ali, you commented earlier in terms of the judges would recuse themselves as appropriate. Now, one of the issues, and you expressed in terms of the evidence you gave, that one of the complainants indicated that if he knew the judge that was dealing with the case was the son of another judge, an appeal judge, how often do you think judges do recuse themselves? And do you think they recuse themselves when it is appropriate?
It's impossible for me to say. I mean, I really, all I can comment on are the people who write to me. That's the only evidence that I have. And I have had people write to me saying that they felt that a recusal should have happened and didn't. Beyond that, I really couldn't comment. I don't know.
So would you would agree that a register, a full disclosure register, because as an elected member of this Parliament, not only do I have to do an annual update of the register, but I also have to do a regular update if there have been any changes in terms of hospitality or other events or organisations that I become a member of. And that's done on a regular basis, not on an annual basis. Do you think that would assist the transparency and openness of the court's procedure if judges were asked to complete a register and maintain a register of interests, and not just pecuniary interests, but also of other interests that they may have?
Definitely, I do. I think the thing that comes through to me in everything that I've looked at, I mean, at the moment, on the Scottish Government website, there's consultation about the Register of Interest for board members. And the word that's used constantly throughout that is perception. And I think that's one of the key issues. It's about how the public perceive people. So it's not, I'm not suggesting that there's widespread bad practice or nepotism or anything of that nature, but I think it's really important that justice has to be seen to be done as well as to be done. And I think, you know, what comes through time and again, I mean, just very briefly, I mean, the consultation that the Scottish Government's doing at the moment on amendments to the Code of Conduct for members of devolved public bodies talks about things like this ensures transparency of your interests which might influence or be thought to influence your actions. And it goes on to, you must consider not only whether you will be influenced, but whether anybody else would think that you might be influenced. You must always remember that public interest points towards transparency. And it goes on and on in that vein. And I think for me that's the issue. It's about the public having confidence in the judicial system. And I think by having transparency, you actually build that public confidence, and that perception will alter. Because the thing that comes through to me strongly in most of the letters I receive is this feeling that people are all in cahoots. I'm not suggesting that the judiciary is, but there's this feeling that, well, there's this system and we don't really understand how it works, and the judicial office holders should have done this, but they didn't, and then I complain to the judicial office, but of course they look after their own. And, you know, this feeling that the whole thing is a big cover-up. And I don't believe generally that it is, but I think because there isn't the transparency, it's very easy for people to believe that that isn't the case.
And that, as you quite rightly said, Ms Ali, is the crux of the matter here in terms of this petition before us, is to try and get that situation where people don't feel that there is a close-knit community making decisions at a very senior level who have either relationships or colleagues that they could be seen to be protecting or supporting in terms of the judicial decisions that are being made in the courts. So could you give, or do you have any indication of how many judges have recused themselves in cases that they've been about to try or have tried?
I'm sorry, I don't know the answer to that.
There may be a question we might want to ask the Lord President in relation to the issue. We received a written submission as a committee from a Mr. Beck, and his written submission, he makes reference to judges having to recuse themselves, which is duly enshrined within the Bangalore Principles. Are you aware of the Bangalore Principles, and what the Bangalore principles set out for as a guidance for judges?
Only in passing. I couldn't claim to be an expert. But I mean, the Bangalore principles are about judicial independence, for example, and cover the issue of recusal. It's left with the judicial office holder to take a decision on whether recusal is necessary or not. But again, I think that's probably a question for the Lord President.
And I thank you very much indeed.
Okay, Anne McTaggart.
Thanks, Convener. Good morning, Ms Ali. Earlier, your initial statement to the Convener explaining your role, out of the 54 cases that you do have, you kind of mentioned earlier that, you know, there wasn't that much power, it was toothless power. What kind of outcomes have you had from some of these 54 cases that you have undertaken?
I think the difficulty I have is that because I have a very restricted role, so when somebody makes a complaint about a judicial office holder, it's investigated by the Judicial Office for Scotland, and they investigate it according to what they call a set of rules. And my role is simply to sit with the set of rules and to sit with the case and to say, were the rules followed? So although I might not agree with the outcome of the complaint, I can only say the rules were followed or the rules were not followed. So it's difficult for me to say, I suppose it's difficult for me to answer that question because my role is simply to say yes, they were followed or no, they were not.
And if they're not followed?
If they're not followed, then I can make a referral to the Lord President. Again, I mean, it's a difference. In England and Wales, there is an ombudsman, and that ombudsman can say, well, actually, I don't think that was the right decision. You need to reinvestigate that, or you ought to do this, or you ought to do that. All I can do is say, the rules were not followed, Lord President. Here you are, and I can make no recommendation as to what should happen. And I'm not clear at this stage. I've written to the Lord President to try to understand whether I will always be told what happens as a result of... So at the moment, I have been told the outcome of my referrals to him. But I, a while back, sent another referral that I understood was going to be reinvestigated, but I haven't heard anything more. So I'm trying to clarify what the situation is, because I suppose my concern is that I might feel that the rules haven't been followed, send it back, and then never know what happens. So I'm seeking clarity on that because the rules don't say what happens at the point at which I then refer something back.
Okay. Thank you.
Just before I bring Jackson Carlo in, you made a comparison with England and Wales about the Ombudsman. The powers there presumably are a lot stronger and also a much bigger budget, I would suggest, than £2,000. Very briefly, could you give some comparisons of the difference between your role and the role in England and Wales?
It's very, very different. In England and Wales, there is an ombudsman. His role is twofold. He handles complaints about judicial office holders or reviews complaints in the same way that I do. And he also does reviews complaints about judicial appointments, which is a completely separate matter. So he does both of those. But being an ombudsman, he can actually ask for an apology, he can ask for another investigation to happen. I mean, he has the full sort of suite of ombudsman powers and can look at wider issues around maladministration, for example. Whereas I feel somewhat as if my hands are tied because I can make suggestions, but I can't do anything more than that. So I can say, for example, I think that the perception of the letters that you wrote were really unhelpful, unfriendly, off-putting, but I can't say change the way that you write letters to members of the public. So I suppose I have to be persuasive in my role, but I have no power to require any change in practice.
And in terms of, you know, administrative backup, is the £2,000 the entire nature of your budget? That seems very, very small.
I have no administrative support. I work from home and I do my own admin. My fees are additional to the £2,000 is for, well, everything except my fees.
Before, apologies to Jackson Carlo, I could just bring Chick Brodie in this point and then move to Jackson Carlo.
Can I ask, I'm somewhat, appalled's probably a bit strong, but in terms of how we close the loop, when you write to the Lord President suggesting a course of action, you say you get no feedback at all?
No, I don't. What I'm saying is, well, I don't suggest a course of action because I'm not allowed to do that. I'll say the rules were not followed. It's over to you now. What I have had up until recently was when the Lord President wrote to the person who'd complained to me, a copy of that letter would be sent to me. So I knew the outcome of what had happened. But recently, there was a case that I referred back, and I was told that that would be reinvestigated, but I didn't hear anything more. And I asked the Judicial Office at one of my quarterly meetings what had happened to that, and they said that they couldn't tell me because obviously it was a matter for the Lord President. So I've written to the Lord President to ask him what I can expect, because I'm unhappy about referring things back and then not knowing what happened. So until now I have found out, but on this one particular case, which resulted in a reinvestigation, I don't know whether it's been reinvestigated or what the outcome of that was.
Are these subject to freedom of information provisions?
No, no. The Judicial Office's work is, the Lord President's isn't, and the Judicial Office's work is only FOI-able if it doesn't involve the complaints handling aspect.
Thank you. Thank you, Chick Brodie. Can I pass over to Jackson Carlo?
Thank you, Convener. Good morning. The petitioner himself has submitted some further evidence which is rather interesting, which points out that the Crown Office and the Procurator Fiscal Service operate a register of hospitality and interests. Therefore, other sections within the judicial system do. It seems without any of the adverse impacts that the Lord President has brought to us. From this committee's perspective, I think that what has been the focus of our attention here has been the Lord President's Edwardian establishment disdain for the hoi polloi, as I think he sees it, in terms of our having any right to understand these matters. And I wonder if you've put it rather more politely, but it does seem to me this morning that you're not a million ways away from characterising this as, you know, is this still the case that the swish of judicial ermine and velvet should cow into deference both the public and the legislature going forward in terms of our right to have some sort of understanding of these issues? And I think the point you make, and if I characterise it, I've maybe been a little bit more colourful, but I wonder if that's how you, if you would agree. But that, in fact, in this day and age, the reason the Lord President appears to be against it is because it has not been so to date.
I can't speak for the Lord President, and I'd like to be as colourful as you are, but I feel I can't at the moment. But I think that with any institution, in any sector of society, change is not always welcomed. I think particularly change that is seen to be quite challenging. And most institutions resist that, and I think it would be fair to say that it's seen as something of a threat, when actually I prefer to see it as something of an opportunity.
Thank you.
John Wilson.
Thank you, Convener. Ms Ali, you gave an indication earlier about how you handle complaints. And one of the examples you gave is where someone had made a complaint of someone sitting on the bench was a relative of someone else who had tried the case, or words to that effect. When a complaint like that comes into you, how do you verify the information that's provided to you when a complaint of, when you use the word nepotism, arises? How do you get the information to allow you to process the complaint to the Lord President?
I don't need to verify it because my role is only to look at whether the complaints rules were followed. So I don't investigate complaints, I don't handle complaints. My role is literally to say, when that complaint was made to the Judicial Office, did they follow the rules? So it's almost a sort of tick box thing. So I'm not looking at the complaint itself or at whether it was genuine or backed up by fact or anything like that. I'm simply looking at, did the Judicial Office do what they should have done with that complaint when it went to them?
At the present moment, what I'm picking up, and you can correct me if I'm wrong, is that you're at the mercy of the Lord President as to whether or not the Lord President deems it relevant or necessary to respond to you and to respond to the complaint.
Yes, I mean, I have no authority to suggest a course of action. If I find that the rules haven't been followed, I can simply say the rules were not followed and pass my report back to the Lord President, and the Lord President then has 4 options off the top of my head there: to do nothing, to reinvestigate, and variations of those 2. But it's up to the Lord President what to do with my report.
In relation to your first option there, the Lord President has the right to do nothing. How do you then respond to the complainant in terms of the issues raised by them in relation to the way they've been dealt with in the courts?
Unfortunately, my role ends when I write my report. So I write my report, I send a copy to the person who asked for the review, and I send a copy, if the rules have been breached, to the Lord President. And I have to explain to the person who complained to me that that is the end of my role, and that whatever decision is taken thereafter is the Lord President's. Inevitably, I get follow-up correspondence from people who say, well, you know, this is what I don't understand why the Lord President decided to do this or decided to do that, or I don't understand this. And so there's often some follow-up correspondence which I try to help them to understand how the system works. But in terms of my role, it stops at the point at which I send out my reports. So there's no challenge to that. That's the end of the process. There's nowhere else except judicial review, which would seem slightly absurd.
You don't have any powers to hold the Lord President accountable for the recommendations or actions or lack of actions that the Lord President decides to take?
No.
Right, thank you very much indeed.
Thank you. Could I just one final follow-up from myself? We've talked a little bit about unintended consequences, and I think we said earlier that the Lord President had argued that a register could impact on the judiciary's privacy. But there's other aspects to that. It could also lead to harassment from the media, hostile individuals, and so on. What's your own view on the Lord President's comments?
I can only talk about my own view as somebody who's completed a number of registers of interest. And that has been that there hasn't been any kind of adverse media comment, haven't been hounded by the press, that there hasn't been an issue. I think at the moment the press, I mean, how would I put it, have it in for the judiciary at the moment. I think the reason being that there is so much lack of transparency. I actually think the complete opposite would happen to what the Lord President fears would happen, that because there isn't transparency, the media feel that there's something to hide, and that they need to investigate and need to go off and find out more. And I think actually if you had the transparency, that would end, because it would all be there, laid out, and anybody could see it. So I genuinely think it would be the opposite.
Thank you very much for that. Does any other member of the committee have any final comments? John Wilson.
Thank you for allowing me back in again. Ms Ali, the Lord President cites the Scotland Act 1998, and it's the section within the Scotland Act that says that judges or the judiciary are not accountable to this Parliament. Do you think the Lord President's interpretation of that section of the Act is correct, and that there should be, I accept in relation to judicial matters when they're dealing with cases at court, the Parliament should hold them to account for those types of decisions. But would you agree that the Scotland Act has to be looked at to allow the Parliament and the public to be able to hold judges, in terms of the register of interest, accountable for the issues that they're involved in?
Quite some distance.
Well, no, because...
Which is about a register of interests.
Convener, the Lord President, as I understand it, has responded to say that they doesn't agree that there should be a register of interest because it's protected under the Scotland Act 1998. And my question directly relates to that Act as it currently is set out, because the Lord President has cited that Act as the reason why he doesn't have to either give evidence to this committee or provide a register of interest.
Just to clarify, because Jackson Howell did ask me to look at that particular issue, the background, I think John Wilson's explained, is that we did ask the Lord President to appear before us, and the Scotland Act has a provision which states that the Judiciary cannot be required to appear before the committee. You may notice, I think the Lord President's next door at another committee. If the Lord President wishes to go voluntarily, that's entirely up to him. However, we have made arrangements for Chick Brodie, the Deputy Convener, and myself to meet the Lord President in a few weeks' time. So that's the background, just because you won't be fully aware of all our previous discussions. I'm conscious of time, so if you could make that a fairly brief answer, that would be very helpful.
Of course. I think it goes back to the earlier point I made about judicial independence, and clearly politicians should have no part in influencing in any way judicial decisions. And I think everyone would agree with that. But judicial accountability is a completely separate issue, and I think being accountable for your actions... I mean, I'm independent of government. My role is also independent of the judiciary. But I'm here before you today because I believe that I'm accountable to the public through Parliament. And you have no right to influence any decisions I make, but you have every right to expect me to appear here before you and to give evidence. And I think the same applies, that separating judicial decision-making, which must remain independent, with judicial accountability, I think that's the issue that cuts through all of this for me.
Well, just before the committee make a decision on the next steps, could I personally thank you for coming along today? I certainly found your evidence very enlightening and very, very helpful indeed. I'm sure I speak for other committee members as well. And I know it's not always easy appearing before a committee, so thank you for that. If you just stay where you are for just a second, the next steps for us to look at what different actions we should consider for the petition. Members will have their own views. Certainly, I still think it would be useful to get the views of Dr. Kennedy Graham, the MP at New Zealand Parliament, who's had a heavy track record on the wider issues around this. But could I throw it over to committee members for their views on next steps? Jackson Callan?
I do think the petitioner, in raising the issue of the Crown Office and Procurator Fiscal Service having a register of interest, and specifically, in fact, dealing with the issues of harassment, privacy, and undue harm to the justice system, which appear not to have materialised, I think it would be useful to get some sort of confirmation of that as the operational outcome, because I think it does go to the heart of the Lord President's assertions.
Useful if we wrote to the head of each of these services rather than...
I think so, yes, in the first instance. Yes, in the first instance. I think it directly contradicts in a very relevant way the concerns advanced as in opposition to the petition.
Thank you for that. Are members agreeable with that course of action? Angus MacDonald?
Yes, I think we should bear in mind one aspect of this morning's session, which highlighted the issue of the JCR's referrals to the Lord President. I think we should seek clarification on the procedure following a referral of cases to the Lord President by the Judicial Complaints Reviewer, and whether they're all followed up. If we've heard of a case where there's one in particular that hasn't been followed up as yet. So given the example we've heard this morning, it may be an issue that you could raise with the Lord President when you meet in
certainly, if the committee are agreeable, I'm sure Chick Brodie and I would be happy to raise it. Jackson Carlin?
I mean, I'm happy for that. I do feel that which I thought was a very important area that emerged today, definitely strays rather beyond the terms of the petition that we are investigating. But I do think it is of material interest and potentially should, following any discussion you have, be referred to the Justice Committee as a matter that they may very well wish to look at if they have not done previously. And of course, we can't know that.
Yeah, that's a fair point. So if committee agreeable, we'll raise that. And then when we come to look at this petition again, we can talk about whether we need to refer other matters to Justice. Would that be acceptable? Other members have checked, Brodie?
I don't think it would be acceptable. I'd love to understand the rationale behind the point that John Wilson made in terms of why and who wrote it into the Act, and the basis of writing into the Act the fact that the Lord President should not declare, or the Judiciary should not declare a register of interest. I suspect we wouldn't get to that information, but it certainly would be very interesting to see how and why and where and when that decision was made.
So the clerk's just advising me, of course, that we can ask Spice to research the debate in Westminster. I think I was actually there at the time, but I'm not sure if I've spoken this. But we will do some research on this and we'll feed that back to the committee as a point of historic interest, I think, that feeds our wider argument. Do members have any other course of action, or are they happy with the points that we've raised? John Wilson?
I'd wish the committee to keep the Scottish Government fully appraised of the evidence that we have received to date on this issue. And Jackson Carlo is right, some of the issues that we've discussed today do go beyond the actual petition and just asking for a register, but I think it would be useful to keep the Scottish Government appraised of the discussions that have been taking place and the issues that have arisen because of our consideration of this petition, and whether or not the Scottish Government would be minded, one, to review the Judicial Reviewer's role in relation to the issues that have been raised this morning, because clearly we have got to build confidence in the judicial system that we have in Scotland, and we have the Ombudsman's position, which is a formal position and can actually make recommendations in relation to public bodies. But clearly we have a Judicial Reviewer that, quite frankly, is not resourced to be able to carry out, I would argue, to the confidence of the general public, the decisions that are being made in the Scottish courts.
And on the back of John Wilson's point, of course we could write, if members are agreeable, to Kenny McCaskill, putting these points to him and getting some feedback which we can discuss at a future meeting if members are agreeable. Okay. So the course of action then is we're writing to Dr Kennedy Graham, the MP at the New Zealand Parliament. We're following up some of the points that Jackson Carlo raised, and we're writing to Ken McCaskill, and we're also going to do some research via Spice on Hansard. And finally, could I thank Moi Ali again for coming along. I thought it was excellent evidence, reopened my eyes on some of the issues on the practicalities here. Thank you very much for coming along, and I'll suspend for 1 minute to allow our witnesses to change round.